Speaker, as this special order has powerfully documented, forced arbitration isn't open, it isn't just, and it isn't fair. Simply put, forced arbitration clauses have become an exculpatory mechanism to rig the justice system. Arbitrators don't have to be lawyers. The decisions are practically irreversible. There is no record kept of the proceeding upon which you could appeal on. There isn't even a requirement that witness testimony be given under oath. As the New York Times investigative series illustrated, arbitration can even take place in the offices of the party representing the defendant. There is also overwhelming evidence that forced arbitration creates an unaccountable system of winners and losers through what's called repeat player advantage process that favors corporations over one-time participants such as individual workers and consumers. An analysis of employment arbitrations found that workers' odds of winning were significantly diminished in forced arbitration. In 2012, the Center for Responsible Lending likewise reported that companies with more cases before arbitrators consistently better results from these same arbitrators. Why? Because they're the ones that refer cases to the arbitrators. The arbitrators want to eat. They know that if they rule against whoever's referring the cases to them, then that's going to cut short their ability to feed themselves. And so they rule in favor of the hand that's feeding them. That's arbitrators who are not even required to be lawyers, and that they have a perverse incentive to favor the repeat business over the consumer or the worker that they will never see again. I'm particularly alarmed by the growing number of companies that hide forced arbitration clauses outside of the four corners of the document. For example, General Mills included a forced arbitration clause in its privacy policy that bound any consumer who downloaded the company's coupons or participated in its promotions, bound them to forced arbitration. Under its new terms, consumers also waived the right to a trial simply by liking the company's page on Facebook or mentioning the company on Twitter. Can you imagine giving up your Seventh Amendment jury trial right on Facebook? It has become an increasingly common practice to use gotcha tactics to deceive consumers and employees by providing so-called notice of binding arbitration in brochures, email and memoranda, job application forms, signs outside of restaurants binding you if you set foot in there and consume, binding you to forced arbitration, in-store application kiosks, employee training programs, contests and games associated with company promotions that people have to watch out. And even on the side of a cereal box, you can waive your right to a jury trial. Just imagine a child finding glass in their cereal, but because the company prohibited class action litigation through forced arbitration, the child's parents would have to individually not go to court, but go to an arbitrator to have their claim adjudicated. And what if it affected several thousand children? That same forced arbitration clause would prevent class litigation to ensure that our children's food is safe to eat. These are actual cases where someone potentially lost their right to hold a company accountable for unlawful conduct in a public courtroom. And in all of these cases, we're not even talking about an agreement with a dotted line. I'm reminded of Justice Kagan's dissent in American Express versus Italian Colors, where she observed that the Federal Arbitration Act was never meant to be a mechanism easily made to block the vindication of meritorious federal claims and insulate wrongdoers from liability. But the tides are turning. Americans are beginning to fight to restore their right to a jury trial. Policymakers are using every tool available to fix our laws so that corporations can no longer escape public accountability. I thank my colleagues for their participation in this special order. And before I close, I want to also thank the Congressional Progressive Caucus for their tireless work to advance a progressive agenda of equality and opportunity for all. I will close with this observation. The American people would fight back if someone came into their home and said, we're going to take away your Second Amendment right to bear firearms. They would fight. But when corporations take away their Seventh Amendment right to a jury trial, they remain mum. But not for much longer. People are standing up. People are tired. They are desiring of change. They're angry. And they realize that they have been taken advantage of. And they want to level the playing field. And that is exactly what the legislation that we have introduced in this Congress will accomplish. And with that, Mr. Speaker, I will yield back the remainder of